The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations of the fourth respondents, which the fourth respondent has no opportunity. In contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck. That indeed is the rulings on the respondent's objection.
Well, as I was trying to explain earlier before we went for the break, we will take all the judgments. After that, my learned brothers will now their own order to save time. Because the petitions are consolidated. So now we will go to the main petition in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 25th February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition and determine the merit otherwise of the petition in interest of justice. At trial, the petitioners opened their case tendering for back several certified true copies, electoral and other documents which were objected to by all the respondents, who reserved the reasons for the objections to the stage of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition, the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses if else drop their off and reserve the rulings for their objection to the stage of final address. That prejudice to the objection, that witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. Fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents and that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and extend their respective final addresses, including separate addresses, support of their various objections which they raised during trial. So we shall now consider the respondents' objections to the competence of some of the petitioner's witnesses and to the documents tendered by them during trial. To save time, we skip the addresses of counsel. So, contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenge the competence PW3, PW4, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath whose witnesses, on oath of those witnesses of the petitioners were not front-loaded along with the petition, but were only filed during trial, contrary to paragraph 4 of 5B of the pay schedule to the Electoral Act 2020. Section 285 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of several provides as follows. An election filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 2022 stipulates the contents of an election petition. The election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition, b, written statements on oath of the witnesses, and c, copies or list of every document to be relied on at the hearing of the petition. Paragraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14 sub 2 of the same first schedule, the Electoral Act, then provides as follows. After the expiration of the time limited by A, Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the original election petition file, or 2. Effecting substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to statements of facts relied on to support the ground for or sustain the prayer election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, affecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian, another versus Mimiko and others, Ugumbi JC, Oba and Vincent, Rarume and others, Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the Apex Court, Ugumbi JC held as follows on the court. Paragraph 4, 1 and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than surreptitious attempt to amend it. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available at which was allegedly not available at the time of into after the statutory time limits allowed for expressly. There is no provision in the legislation which provides for extension of time. What is more, in paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134 sub 1 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart, mind. The use of the word shall in paragraph 14, sub 2A of the first schedule to the Electoral Act mandatory and places a complete bar on any form of amendment to a petition file, does not allow for an exercise of discretion whatsoever. Further still, on a critical threshold of the application, relief 2 seeks to call additional witness to which with AEO. It is pertinent to state that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285.5 of the Constitution, section 134 of the Electoral Act, clause of court. In his concurring judgment in the same case, Nguta, JSC, specifically stated follows, a court. The additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts as found by the tribunal and which finding was endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court to do so. Election petitions are time-bound and the court will not allow the party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act that petitions be disposed of judiciously. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Lasun versus Awoyemi Supra to argue that the 15 witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because that they are subpoena witnesses who do not work for the petitioner. However, it is pertinent to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidran and Ete and Lasun versus Awoyomi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5 of the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of Section 285, subsection 6 of the 19th Constitution of Federal Republic of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing of the petition. Thus, while this court in Omidiran and Ete and Lasun was appeared to have latter decision in Oko and Miko. In subsequent following the appeals court's decision in Oke and Mimiko, this court, per Agim JCA, as he then was, now JSC, elected this strict position of the law in Ogba versus Vincent at paragraph 46, 48, paragraph 8 to B, wherein he held as follows, our court. I think that this court in Omidiran and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether the tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits described in Section 141 of the Electoral Act 2006. The provision in the first schedule thereto on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings in paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition, held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and court practice directions as overriding the rules of court in election court cases. In Oke and Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach, opposing the electoral laws. The law, as laid out systema juris in Oke and Mimiko, is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored that procedure, laws of court. The firm position of the Supreme Court, as stated in Oke and Mimiko and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 285(5) of the 1999 Constitution, Section 137, Subsection 7 of the Electoral 2022, and paragraph 4, 5, and 6 and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 8 of Federal Law. Time limited for filing of a petition has elapsed. The contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath the witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses be called ordinary or expert witnesses and was subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54, in relation to